I'm Chris Gros, joined by always Jack Hull here in the seat to my right, on screen left here, if you will. Today is a big day if you are a follower of SCOTUS block. This has been sort of like a knockout stage game, if you will, in the round of 32. We have seen a number of rulings come out here and also a lot of anticipation that has been built up for a ruling that we expect to see now maybe tomorrow. But we want to start with a live look here at the Supreme Court in Washington, D.C., Jack, where the 9 justices are expected, of course, to continue their rulings here ahead of their summer recess. In fact, I believe tomorrow is the last day for the release of rulings, correct?
That's not confirmed, but that's what we're hearing.
What we're hearing and is expected.
Yeah, so, they adjourn. They have a summer recess, which typically early July is that case. There's only about 4 major cases left on the docket. We're going to break down what was decided today. We're going to break down what we can expect tomorrow. But 4 major cases, a lot of the much larger, more consequential ones. There was a few consequential ones today. I'm not trying to diminish that in any way, shape, or form. But as we've mentioned, there is a major one that we are keeping an eye on. Every time you have a docket here, every year or so, or every few years, many cases are decided. Many decisions as to whether they'll take up cases are decided. But oftentimes there is that one, that there are that 2 or potentially 3, depending on certain terms and certain sessions, where there is just a handful of cases that we're really looking out for, ones that we know are going to have mass precedent, mass consequences here throughout the country. Today's one of those days.
Yes.
Chris?
Yeah, it truly is. And obviously, the case that we're talking about in terms of the focus, of course, is birthright citizenship. I mean, we already know, of course, that there are a number of cases. As you said, we're gonna jump into the rulings that were today, but we're also still waiting on, I believe, campaign spending caps, transgender athletes, and mail-in ballots. That's something that we heard today that we'll break down. But then, of course, we are going to talk about birthright citizenship here. I think we should start breaking it down because we kind of, again, pull back the curtains. We went into today's show expecting that we might get a ruling during the show. So we wanted to heavily focus on birthright citizenship. One of the good things about that is that you went so in-depth in putting this together that basically when this ruling is released tomorrow, if you're watching right now, you're going to feel prepared. You're going to know what birthright citizenship is, why it's been so heavily contested in the history of the United States, and what the arguments both for and against it are. So this is also still a really useful tool.
And we're going to break down a lot of this stuff again tomorrow in case you had we're going to be talking about this for a little bit. So if you step away, continue your morning business, go to work, get ready for work, and you don't have that, we're going to break it down again tomorrow, a little bit more abridged than it is today, but we're not going to jump into the decision without, of course, providing that necessary context. So we're going to try to get you as caught up today and tomorrow as we break down what is expected to be that major decision tomorrow morning.
All right, so birthright citizenship is, of course, this long-standing idea that a child born in the United States automatically becomes a U.S. citizen regardless of their parents' immigration status. The U.S. is one of around 30 countries that do this, and around 50 more have limited versions. So it is different, obviously, depending on where it is that you're living. Birthright citizenship has been the law of the land for nearly 160 years. But if you notice there, as we are about to celebrate 250, I did not say 250 because it's something that was not necessarily thought to be as obvious up until we saw some of the very first Supreme Court rulings and eventually the 14th Amendment. But of course, that could change this week, Jack.
Yeah, on the first day of President Trump's second term, he signed an executive order that attempted to curb citizenship to children of non-citizens. It's yet to be enforced. This was one of those, like many of President Trump's executive orders, this one in particular, this one was met with immediate backlash, especially in the courts. We saw multiple injunctions. We saw multiple nationwide bans. So it's been almost a year and a half since this executive order was signed. It's actually been almost exactly a year and a half. But we still haven't seen it be enforced because of this legal battle that began at the genesis of it being signed. So very swift legal battle began all leading up to this week. So there's a lot to break down here. We said 160 years of this. This is an idea that traces back to the end of the Civil War. And that's where we see a lot of debate the conservative principle or those who are against birthright citizenship. We say conservative, but it's not as easy as that. So I don't want you to think that that's what we're equating to it. It's one of those things where many people who are against this concept of birthright citizenship do lean to be conservative, but we're just going to say that for terms of simplicity.
Yeah.
We don't want to, create a monolith of it. Of course, it does exist people who lean on the liberal side who perhaps don't think birthright citizenship is the case. There's a lot of European countries that we think of as quote unquote liberal that don't have this concept. In fact, birthright citizenship is something that is more common on the Western Hemisphere than it is on the Eastern Hemisphere. So you're seeing it a lot more in these countries here in North America and South America than you do in Europe, for example. There are European countries that have it to a certain extent, but it's not entirely the case. The reasons why, I'm not entirely sure. I think the easiest assumption I can make on it is that New World, Old World testament to it. This was an area. These were two continents that were discovered by Europeans. So the culture and the way in which these countries were founded was greatly different than the centuries and centuries of background history that you saw there in Europe. I don't know if that's necessarily the case or not. I just know that that's off of the top of my head.
Yeah.
Some of the context between these countries' histories that might explain to some extent that differentiation.
I believe there's also like the nobility aspect of it as well, too,
Of course.
Of any countries that had royal families that ruled. I mean, notably, I believe France, it is notably hard to get your citizenship,
Sometimes.
if your parents aren't of French ancestry.
Yeah, a lot of times there's the Latin word for it that escapes me right now, but there's birthright citizenship, which is based on land technically, and then there's citizenship that's based on blood. We are a land country. Yeah. So with that all out of the way, let's start with the background here. Until the 14th Amendment was ratified in 1868. The Constitution, early federal law.
Nearly 100 years. Yeah.
Citizenship wasn't necessarily something that was talked about. Oftentimes prior to this, it was white landowners. That was later extended to just white citizens, specifically white men. It wasn't until the 1920s when women got the right to vote. Nonetheless, they had citizenship to some extent. But when it came to citizenship, it was that people who were white, who were born in the United States, were Americans. And it was left pretty much at that. Of course, we mentioned the 14th Amendment. That was part of a slew of amendments that were ratified at the end of the Civil War. So when we talk about what this amendment, of course, we have to talk about the Civil War. And to a further extent, we have to talk about slavery, the abolishment of slavery, and a lot of the effects thereafter. The legal status of enslaved people and the growing population of free black people was left unresolved. Without citizenship protections, free black people faced violence and the risk of forced relocation. So the Citizen Clause was a direct rejection of the Supreme Court's infamous 1857 Dred Scott v. Stanford decision, which held that African Americans could not become American citizens and had, quote, no rights which the white man was bound to respect. Of course, that refers to a man who was escaped slavery in the South, went to the North, tried to claim citizenship. That was a very controversial Supreme Court ruling that essentially said that because you fled and you went to the North where slavery was abolished, that doesn't necessarily mean that you are a free man that has citizenship. You are still property.
Yes.
That, of course, was something that was reversed by the 14th Amendment. And we're going to get into the verbiage. I'll let you take it away from here. But it is that verbiage.
Yes.
We'll go into the debate on it after we take a break here. But we want to just talk about what that verbiage is to begin with, to kind of set the stage for the debate that continued, not just from, that we're seeing today. This has been for a lot of the 20th century, especially into the immigration trends we've seen in the 21st century. But again, it all started right here.
You'll hear Dred Scott be brought up oftentimes if you've been around enough to see maybe a Supreme Court justice be questioned by Senate colleagues. It's sort of a litmus test. Do you believe that the Dred Scott case was a correct one? That's oftentimes a very common question that you will hear from senators. That's why it was such a big deal. As for the 14th Amendment, though, Section 1 states, quote, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the states wherein they reside. Congressional records indicate that the broad guarantee of birthright citizenship was always intended to include the children of immigrants, regardless of their parents' legal status. Senator Jacob Howard, we are going back here, explained during the 1866 debates that the clause was, quote, simply declaratory of the law of the land already, that every person born within the limits of the United States. So you mentioned that land argument there. Again, born within the limits of the United States is by virtue of natural law and national law a citizen. Senator John Conness confirmed the proposed language, declared that, quote, the children of all parentage should be regarded and treated as citizens of the United States, entitled to equal civil rights with other citizens. I think that's important because I think sometimes the documents, the language that is used in documents can sometimes be left up to interpretation of what it is that maybe these lawmakers thought of at the time. But here we have direct quotes from the actual lawmakers themselves about what it is that they believe it intended.
And I think it's important to note here that you will learn as we continue here. We've already touched on it a little bit. The legal precedent for the idea of birthright citizenship is something that's well documented throughout.
Yes.
So when we've talked about the oral arguments that took place here earlier this year. That was the one that President Trump attended. That was a precedent shaking thing. The main takeaway from that is we'll talk about this a little bit in more detail later, but it's important we bring this up now just for a clarification and a little behind the scenes purpose. Is that you mentioned it right there. Those are two examples of when this was being ratified, during that ratification process, during the debates, that this concept was well established about the broad scope of it. So you're going to hear us, perhaps, we want to make this clear, not necessarily advocate for a certain ruling either way. We are simply acknowledging that there is a vast amount of precedent that perhaps could contradict what you're hearing from the Trump administration on this. And I want to make it clear here. You mentioned in that quote from former Senator Jacob Howard where he uses the word already, essentially saying that, of course it was extended to white people at this time prior to the ratification, but the idea is prior to 1868, if you were an Irishman, and you had immigrated here to the United States, and as soon as you set foot, you and your wife had a child, that child would be an American. It's just later expanded and solidified to add newly freed black individuals as part of that collective.
They very clearly state all persons, that Section 1 there of the 14th Amendment, all persons. So again, I believe, as you said, they were trying to encapsulate that, essentially cementing that and codifying it, if you will, that it would be all persons, not just white males. And I think it's also important to point out that this is a topic. We'll get to the quote by the Chief Justice, where we're talking about different times and so forth. I mean, this is not a situation in which the U.S. as a country was trying to deal with, let's say the question of like the Second Amendment, where there have been a lot of discussions about, like, with the Second Amendment, obviously technology has changed with weapons and what were the intentions and so forth. Birthright citizenship, while maybe the status and the people and the countries where they're coming from are different, the very core argument is still a lot the same, both the detractors as well as the supporters. So it is maybe not necessarily a mirror, but I do think that it is a pretty close argument to what the debates potentially that were ongoing in the 1860s and even prior. So I think it's very interesting to look at that. Now, obviously, in 2023, we did not have the population numbers back in 1868. So maybe some of these numbers, they would argue, if you were to bring back, the 1860 senators, hey, this is a little bit different. But nonetheless, I think it's cool that we do have this information here about the scope of who is impacted by birthright citizenship. In 2023, mothers who were unauthorized immigrants or had legal temporary status in the U.S. had 320,000 babies. That's in the year 2023 alone, representing about 9% of all 3.6 million babies born in the U.S. that year. The number of babies born to unauthorized immigrant parents peaked at approximately 390,000 back in the year 2007. So this is not a situation in which we are seeing those numbers continually increase each year. There are peaks and there are valleys, and the previous peak is nearly 20 years ago. So that number dropped 36% to about 250,000 in 2016. Trends that generally follow the growth and decline of unauthorized immigrant population, again, peaks and valleys. Currently, approximately 4 million U.S.-born children under 18 live with at least one undocumented parent, confirmed by the Migration Policy Institute. Births to mother with legal temporary status, foreign students, guest workers, and others have hovered a little bit lower, 15,000, 30,000 per year since the late 1990s. About 9,000 births in 2023 were to mothers who were residents of foreign countries, the birth tourism category.
That's a thing you'll hear from a lot of people who are against this concept of birthright citizenship.
But they remain residents of other places, and they come here to have their children so that they can become Americans.
And I would say a timely example of this concept, birth tourism, I think there's a negative connotation that associates with that. There are situations in which it is not necessarily an intentional thing, rather a circumstantial thing. One of the great examples for it is Balogun, someone who's on the U.S. men's national team, born to Nigerian parents. They were on a vacation as they were studying abroad. They were actually on their flight to get back to, I believe it was London, where they were at university. But she was so pregnant that the flight, at the gate, they said, no, you can't. You can't go on this flight. You're too pregnant. You're about to have this child. That child was born in the United States. Although he grew up in London, he went through the soccer system up there. He actually played for the U.S. men's national team.
And I don't think that anybody would accuse his parents of intentionally it just was circumstantial. They were trying to get home, and they were literally not allowed. Now, as you mentioned, there is the negative connotation of birth tourism, though. But that's an example of it can also be happenstance.
So that 9,000 that we're talking about in 2023, we have no data as to confirm the motivation or intent from that. So we want to make that clear because we know that there is a certain assumption that comes to that word. It's not always just a ploy to get your child's citizenship or anything like that. Okay, so let's talk about polling before we take a break here. What do people think about this as we go into the ruling? We actually have a study from just about 5 days ago. This is from Quinnipiac University. They found that approximately 69% of Americans say birthright citizenship should continue, compared to 27% who say that the Supreme Court should reverse the ruling. About 4% either undecided, no opinion, regardless of whatever it is, they didn't have a yes or no answer on it. So this is a concept that has general support. Now, that's a little bit of a vague question because you mentioned that quote unquote birth tourism category. There are people I've heard anecdotally who support the concept of birthright citizenship, but perhaps aren't necessarily in love with the idea of what is referred to as birth tourism. So it's not as black and white as I think that study necessarily would show. There is nuance to the argument. But all in all, just to put a button on it before we take a break here, and we break down some of the debates that continue on it, the idea of citizenship by land here in the United States is one that is broadly popular.
Yeah, it is. And it is one that I think if you go back and look at a lot of families, you'd be surprised. This isn't just a situation in which, you mentioned, the Great Irish Migration. If we go back to even prior to the 14th Amendment, there are a lot of families that are here because of that ability, because of land and birthright citizenship, that they were able to now have future generations here that are just considered to be American, right? Like you don't think back to it. But again, this is more than just something that only benefits the people of today. This is something that has, as we have laid out here, a history to it. And to be surprised how many people are impacted by this history. All right, that's going to do it for us for our first segment here on birthright citizenship. We are going to come back here, continue this, including the historical debate. As we said, this might be polling really well, but it is still one that is hotly contested. We'll have all of that and the test case here when we come. Welcome back, everyone. This is Right Now. It is Monday, June 29th, and I'm Chris Gros, joined here by Jack Hull. We've been going through the case of birthright citizenship, or at least the history. And now we're going to talk a little bit about the debate, because while this is something that, as we ended our last segment showing that poll, where 69% of those polled wish to keep this in place, this has been something that's been hotly debated throughout our country's history as we are getting ready to celebrate 250. A reminder, it wasn't until the 14th Amendment that this applied to all citizens, all people versus just white males, codified with the 14th Amendment. So there's been a bit of tricky history, if you will, Jack, with this. And so critics of the broad sort of policy of birthright citizenship, they point to the phrase, subject to the jurisdiction thereof. Now, that is a critical conditional qualifier. Its original meaning, they say, refers to the political allegiance of an individual and the jurisdiction that a foreign government has over that individual. The conservative argument, the fact that a tourist or undocumented person is subject to U.S. laws and courts does not place them within the political jurisdiction of the United States as defined by the framers. As evidence, critics point to American Indians. Their children did not become citizens until Congress passed the Indian Citizenship Act of 1924, which they argue would have been unnecessary if the 14th Amendment extended citizenship to every person born in America, regardless of circumstances.
Yeah, on the main road of the argument we're making, we're actually going to take a quick exit. We're going to take the scenic route to describe that act in particular in the context between that, because there's a little bit of, I would say an exception of sorts to explain what that act does, especially in the context of this. So the Indian Citizenship Act was passed due to an exclusion that was created as a result of the amendment. At the time, Native Americans were excluded, not because there was anything racial regardless to it, but because they were part of tribes. And these indigenous tribes, in the eyes of the lawmakers, in the eyes of the Supreme Court, weren't viewed as Americans because they viewed those tribes as separate sovereign nations. Yes. You think about all of the tribes throughout our history. You know, if you ever see the map of a pre-colonial America and it outlines all of the different Native American tribes, all the indigenous tribes, all of those are their own nations.
Yes.
In a certain extent. So despite all that we saw in the preceding decades between the relationship between the Americans and these Native American nations, nonetheless, they did, at least in this context, view them as sovereign nations. So only those who were taxed, quote unquote taxed, various definitions of what that could mean, had served in the U.S. military, married a white American. Remember, prior to this, it was white Americans who were granted citizenship, or accepted land allotments were granted citizenship. So, out of the whole population at the time, 1924 here, for example, or in the years prior to that, it was only a very small handful of Native Americans who were actually considered U.S. citizens under this definition. This was an exclusion that was further established in Wilk v. Wilkins, which ruled that simply leaving one's tribe and settling among white Americans didn't equate to citizenship. So in a weird way, a little inverse of what it is in this case here, especially because it does have to do with a different nation. So it was it's an interesting exception. Defenders of birthright citizenship, however, they counter that all three branches of government had long interpreted the language as a broad grant of citizenship. So to kind of recap here on this argument, and we're actually going to see this argument be played out in real time in our next block as we kind of go over what we saw in the Supreme Court earlier this year as these oral arguments were taking place. You'll see the Solicitor General try to make this case in some contested exchanges with both Justice, liberal justices and, of course, you mentioned the Chief Justice, often viewed as a conservative, John Roberts. So in one of their key pieces of legislation is this law that was passed in 1924. However, there is a key legal precedent which took place around 30 years earlier. It wasn't a piece of legislation. It was a Supreme Court ruling itself. And this oftentimes is being cited as that benchmark ruling that further solidified this idea of birthright citizenship.
That precedent that we all learn about when we're taking U.S. history or, learning about the Supreme Court and sort of, again, their place here in American government. The key legal precedent, of course, U.S. v. Wong Kim Ark. In 1897, Wong Kim Ark, son of Chinese immigrants, was denied entry into the United States despite having been born and lived in California his entire life on the basis that his citizenship was invalid. So his entire citizenship was being questioned. The Supreme Court ruled that in that 1898 case that the 14th Amendment guarantees birthright citizenship to anyone born in the United States, including the children of parents who are not U.S. citizens, with only narrow exceptions such as U.S.-born children of foreign ambassadors. Conservative legal scholars argue that Wong Kim Ark decision only held that a child born of lawful permanent residence was a U.S. citizen, which they say is a far cry from saying a child born to someone here illegally must be a citizen. Congress codified birthright citizenship in a statute in 1940, repeating the 14th Amendment's language, including the subject to the jurisdiction thereof clause. So, again, this was that case that oftentimes gets referred to back there, but then also that 1940 law codifying it. Again, seemingly you would think that this and everything was in place, but as we have learned here this year with that executive order, it is not in all just cemented and in place with birthright citizenship.
Yeah, a couple of things here. You know, you mentioned that narrow exception as U.S.-born children of foreign ambassadors. Essentially, what we're talking about is the inverse of let's say someone who was born overseas to military parents. You know, there's multiple examples. We talk a lot of sports, so we think of athletic examples oftentimes to kind of contextualize what we're talking about. There have been football players. Tim Tebow, I believe, was one of them, where his parents were on base. When, overseas, he was born on that military base or near that military base. Because of those certain exceptions, they are a U.S. citizen. However, in the very inverse operation, if you're a diplomat from, let's say, Turkey, and you're here, at the embassy and you have a child there, that is that rare exception, according to this law, in which you are not a U.S. citizen.
John McCain, very famously, also born overseas. And again, while you don't have to be to become, I believe you don't have to be a U.S. citizen to run for Senate, though I might be wrong about that. But regardless, when he's running
Senate
for president, that is required.
Be.
So had he won in 2008, he would have actually been the first U.S. president born on a military installation.
Exactly. So there are exceptions here. And then another thing where you mentioned that codification, oftentimes if you see a Supreme Court ruling that strikes down a certain precedent, one of the questions that you'll see is, was there a law that was passed in the time of that previous ruling to codify that language? A lot of times that is viewed legally as another safeguard against whatever principle it is that advocates for said principle care about. That was something that we talked about with abortion access for a long time, and the advent of that Dobbs decision was in the time between Roe v. Wade versus the Dobbs decision. There wasn't whether it was a lack of necessity that was the viewpoint of certain lawmakers at the time or whatnot. There wasn't a law that was passed to codify it on a federal level. So a lot of the idea of abortion access nationwide often hinged on that Supreme Court case in its entirety, and there wasn't an extra stop to it. So when you're hearing defenders of birthright citizenship say that you're seeing this covered, explained, codified across multiple branches of government, they're going to make that argument that this is something that is far more ironclad than perhaps something like the Roe v. Wade decision.
Yeah, and again, this was not something that I don't think that a lot of people had on their agenda as something that could, because of all of that this was something that might be challenged. And yet here we are. We'll get into why it is and how it is that we got to this place in the more modern sense, if you will. We're going to take a quick break, and we'll come back and we'll break down that executive order and then some of the oral arguments that have been made in front of the Supreme Court. All right, welcome back, everyone. This is right now on the sort of, again, the anticipation that we are going to be getting a ruling here on birthright citizenship in the U.S. by the Supreme Court. We are breaking down the history behind this process, this long-standing tradition, I guess you would say, in the United States. But now what we want to break down here is the challenge to it, because as we mentioned, there is there are a couple of Supreme Court decisions that have already taken place on this topic. We have the 14th Amendment, we have the 1940 codification of said decisions and everything that goes into this process. But now, how did we get to the Supreme Court yet again? Let's talk about the challenge. On January 20th, 2025, on his first day in office, President Trump signed Executive Order 14,160, titled, quote, "Protecting the Meaning and Value of American Citizenship," which directed all executive branch departments to refuse to recognize citizenship for children born to undocumented immigrants or visa holders. So not just those who were in the country legally, but also those who were doing, as many would call it, the correct way, right? Like having that visa. The order specifically stripped automatic citizenship in two circumstances. One, when the mother was unlawfully present and the father was not a citizen or lawful permanent resident. Or two, when the mother's presence was lawful but temporary and the father was not a citizen or lawful permanent resident. 3 days later, a federal judge in Seattle temporarily barred the administration from enforcing the order. A senior U.S. District Judge, John Coffenheimer, a Reagan appointee, told a Justice Department lawyer during a hearing that Trump's order was, quote, "blatantly unconstitutional." Attorneys general from 22 states and several immigrant rights advocates sued the Trump administration. 56% of U.S. adults disapproved of that order.
Yeah, we mentioned that earlier. The legal pushback to this was very, very swift. It said 3 days later. Yeah. So when it comes to enforcement, this hasn't happened yet. So if you are someone who could potentially have been affected by this, you are probably, there's a chance that you're still here in the United States because of a reason like this. This hasn't been able to take effect in almost a year and a half since it's been signed by the president. But, however, there are potential effects to keep in mind here, and we want to try to give you an idea of what could happen, for example, had that enforcement had taken place. There's about 260,000 children right now that would not have qualified for birthright citizenship if President Trump's executive order had already been in effect. A status would not be retroactively affected by President Trump's order, so something to keep in mind here. On January 19th of 2025, if that's when you were born and you were born to parents of non-citizens, you would still be an American under this executive order. This is not something that retroactively revokes citizenship. It is something where from this date, that is no longer the case. A 2015 study found that repealing birthright citizenship could also cause the number of undocumented immigrants to go up by more than double, by 4.7 million in 2050. Of course, mainly the reason is that those children who were born by non-citizens, who are often in all cases granted U.S. citizenship due to this concept, would not. So you would have a vast population of people who normally get U.S. citizenship under what is currently U.S. law. If this executive order took effect, they would also be illegal immigrants. So that would be the case. And that would, we've talked about a lot of the issues when it comes to illegal immigration and the backlog of immigration judges and how that's often been one of the key points that you hear when you're talking about what is often regarded on both sides as the broken system of U.S. immigration, is that backlog where oftentimes you're not able to, it takes forever for someone to get that day in court, even if they cross the border illegally or if they're trying to get their pathway to citizenship, whether that's the asylum process, whatever it is. So that would just further strain it, is what this study is trying to say here. So we talked about what it could do, but of course, those effects are purely hypothetical at this point. We hadn't seen it take place yet because that was so swift. So the Supreme Court ruled last year in a 6-3 ruling that federal district courts generally cannot issue nationwide injunctions. So the Supreme Court did have a say on this case already, Chris, but it wasn't on the merits of birthright citizenship of that question itself. A lot of it had to do with these nationwide injunctions that you were seeing lower federal judges take here. So it didn't necessarily strike down that law, but it did kind of limit and hamstring these lower courts' ability to issue these blocks on it.
Yeah.
So there was a lot of conversation about what this meant for birthright citizenship, and in a large part, it really meant nothing at the time.
Because essentially what they were saying is that why should a judge in California, even though it's a federal district court, why should that nationwide injunction be applicable to the entire all 50 states, correct?
And you've heard this, and you've heard this is something that has increased over Republican and Democratic presidents over the time. So this isn't
trying to
necessarily
get cases
just
in front of certain judges.
This isn't necessarily just a President Trump, President Biden, a President Obama kind of thing. This is something that you are increasingly seeing be utilized, these nationwide injunctions. And you've heard President Trump talk about it. He calls them rogue justice or rogue judges. A lot of times he's referring to this concept of nationwide injunctions that, stop something dead in its tracks before it goes to the Supreme Court, should they choose to take it up. So on the day of that ruling, the ACLU filed a class action lawsuit in the U.S. District Court of New Hampshire on behalf of children who would be denied citizenship. The name of the case is Trump v. Barbara. The representative plaintiff is a Honduran citizen, just known easily as Barbara, for fear of her safety. In December of last year, just about 6 months ago, the Supreme Court agreed to take the case. On April 1st of this year, we actually heard those oral arguments. And we're going to get into this example. What you hear in oral arguments, a lot of times you'll hear the court reporters and you'll see the headlines on the major newspapers. Their headline will usually be a tell as to what they believe the ruling will be. We've learned today that that is not the case. So we're going to break down what you heard in those oral arguments, and it's going to sound like the justices, the vast majority of them, are leaning one way. But we'll break down some of these other court decisions from today specifically, where it was a case in which we thought that something was going to be ruled in favor of the challengers, but it was not. So we want to make that clear that what you heard today, what you're going to hear right now, isn't necessarily going to be indicative of what we might hear tomorrow.
Correct. But we have seen that this version of the Supreme Court, if you will, this current makeup, has been very favorable during President Trump's second term to a lot of the issues that have either been linked to the president's agenda or are direct challenges as part of the Trump administration. They have been viewed as favorable to his agenda. But today, again, as you noted, we saw a bit of a reversal, if you will. Just last week, though, the Supreme Court handed President Donald Trump a pair of wins in two major immigration cases. One of them clears the way, we talked about it here on the show, for the White House to restart its controversial asylum policy. It aims to curb the number of migrants processed at the southern border. This is that process known as metering, who claim to be fleeing political, racial, or religious persecution in their home country. The policy would turn them back before they ever step foot on U.S. soil. Additionally, the Supreme Court ruled in a case dealing with temporary protection status. It allows migrants from certain countries facing strife to legally remain and work in the United States under that active designation. We've heard this topic. Springfield, Ohio, a number of Haitian migrants who are now impacted by the reversal. It was actually the case involving both Haitians and Syrians that this was sort of rolled back on. And a lot of people feel like TPS has now essentially lost its teeth for all people. However, again, it is not a fully dismantled program. But again, a lot of people fear that though Haitians and Syrians are being identified as the two groups of those countries of origin that are mainly impacted by this, there is wide-standing belief that this has essentially eliminated some of the protections given by TPS. Now, the court said the Trump administration could end those, again, impacting millions of foreign nationals. It aims to curb the number of migrants processed. So this would essentially... those are two big victories there that we saw in recent cases, both the asylum and with the TPS status.
And all that's to say is that the Supreme Court has generally, in a lot of these rulings since he came into office, has been pretty favorable to his agenda, not necessarily his agenda, but his power to execute that agenda here. But that takes us to those oral arguments that you saw there in April. Solicitor General D. John Sauer argued the citizenship clause was intended to give birthright citizenship to those newly freed from slavery and their descendants, not to, quote, the illegal or the children of temporary visitors or illegal aliens who lack the direct and immediate allegiance to the United States that lawful domicile creates. We talked about that idea of domicile here earlier. He also, much in line with that traditional conservative viewpoint we discussed earlier, argued the phrase subject to the jurisdiction thereof refers to the political allegiance of an individual and the jurisdiction jurisdiction a foreign government has over that individual. Take a listen as Sauer explains this viewpoint in an exchange with Justice Ketanji Brown Jackson.
Are you saying that only people who are domiciled here, as you define it, can form the necessary loyalty to the United States?
It's not allegiance is not a question of subjective loyalty.
Okay.
Oh, it is something you owe. It's a reciprocal relationship between the citizen, whether they want it or not. They have that allegiance, and I think it's powerfully
on the basis of what?
Domicile. I mean, that's what it says in so many words in the Venus and the Pizarro. It says, look, if you're talking about an alien, if they're just temporarily passing through, no, they don't have allegiance. But if they've made it their permanent home, they become part of our political community, and they are analogous or akin to citizens.
So there's that birth tourism idea that you were talking about. If you're passing through, we talked about the U.S. men's national team soccer player. That's a situation in which he's referring to here. So Justice Sotomayor pointed to congressional debates where lawmakers explicitly considered the amendment's application to immigrants lacking legal status. We talked about that earlier. Those those senators from the 1860s who, according to their words, made it very clear that this was as all-encompassing as the interpretation has been for a while, in contrary to what you're hearing from the Trump administration. However, Justice Gorsuch challenged the government's domicile argument based on historical evidence that without strict immigration laws in the 1860s, it was much easier to establish domicile than today.
Yeah, and then there was, of course, the exchange that we talked about. Chief Justice John Roberts asked how the known exceptions to birthright citizenship, children of diplomats, and invading armies could be extended to immigrants lacking legal status. Take a listen.
I think it's, I quote what Justice Scalia said in his Hamdan dissent, where their interpretation has these implications that could not possibly have been approved by the 19th century framers of this amendment. I think that shows that they've made a mess. Their interpretation has made a mess of the provision.
Well, it certainly wasn't a problem in the 19th century.
No, but of course, we're in a new world now, as Justice Alito pointed out, to where 8 billion people are one plane ride away from having a child who's a U.S. citizen.
And Chief Justice Roberts responded, while it's a new world, it is the same Constitution. So legal analysts are generally reading the room here. They're listening to oral arguments, and they believe that, again, while those don't always predict the outcome, that they are going to tilt in the challenger's favor by keeping and preserving birthright citizenship.
That being Barbara, the ACLU.
Barbara, the ACLU. So we don't know. And I don't know if it's an indication of anything, but this has been one that we anticipated to be released on Thursday. We thought maybe, okay, it could be Friday. Now we get to Monday, not there. Another sort of wrinkle in all of this is that in an unprecedented mood, President Donald Trump attended a portion of the oral arguments, a first for any sitting president in official records. Now, again, it is expected that we will get the high court's ruling tomorrow. We will, of course, be on standby. A lot of times these rulings are handed out prior to our show starting, so we will likely have full reaction, maybe even potentially special reports going on. We'll bring you all of that.
Yeah.
But that wraps up our birthright citizenship discussion. And again, in anticipation of likely a decision being handed down tomorrow, we are hearing that the court will likely be taking their recess soon. We know there's about a handful of cases that they still have to issue their rulings on.